and my lady. I was going to go to Ong and Ping, which is at Authorities Bundle 3 at tab 91. It's a case that the court's already been shown. 1962. And if we could start at page 15, please, of this extract. Sir Colin Reimer gave the leading judgment, refers in the second part of paragraph 40 to the submission of counsel that the question came down to what a reasonable person armed with all the background knowledge that would have been available to the settlor would have understood the sense of the documents to be. In our case, that would be the reasonable person with the background knowledge available to NIOC. What would they have understood the mortgage documents to? Would they have understood the mortgage documents to mean that NIOC was declaring a trust? Is it creating a trust by these documents? And so Colin Reimer applies this test. You can see through the judgment he refers to the reasonable person test multiple times. And it's evident that he also considers all potential indicia of Madame Lim's intention, including correspondence with her solicitor and the legal advice she received and so forth. And I also draw attention to the fact that the court was looking for, and this is particularly apparent from two passages, at the foot of page 18, paragraph 54, the court is looking for Madame Lim's intention when she signed the 1986 deed. And that's the passage. I won't read all of 84, but if we go to over the page and page 19 towards the end of 84, just picking it up in the last 5 lines, that is what she must have taken to have understood up to the moment when she signed the deed. And the inference is that when she signed it, she must have intended the house to become subject to the trust of the deeds. That was the objective of what she set out to achieve. Now, there's a similar focus in paragraph 58 on page 20 of our report, when the judge says, in my view, therefore, if you were provided with a correspondence passing between Mr. Hyde and Madame Lim up to and including the letter for 14th April 1986, the reasonable person would have no hesitation in concluding from it that when she signed the settlement, Madame Lim understood and intended that the house should thereupon become subject to its trusts. So the court is very much focused on what the intention of Madame Lim was when she signed the settlement document in 1986. Is it? Yes, 1986.
And just to be clear, was that the moment of declaring the trust? I know it wasn't when...
Yes.
That's what the court found.
Well, it's a little bit ambiguous towards the end, because there's this business about the reservation at the end of the judgment. It's on the 2 pages that we're on, because effectively what had happened was that Miss Justice Morgan below had found that the April 86 document was sufficient. And the reservation that Sir Colin Reimer refers to is that the 1986 document, the house was referred to arguably, that it may have been arguable the house was being referred to for a different reason in the earlier documents. And he said, well, if that reservation is justified, if it's justified, he says in the last paragraph, the later letter NOE provides clarification.
Sorry, I think we're at cross purposes.
Oh, sorry.
I know that the 1988 document ultimately provided the evidence.
Yes, sorry.
But
yes.
Did the Court of Appeal confirm that it was the trust settlement document itself that created the trust, albeit it didn't?
Well, that's my reading of the judgment, my lady. As I say, it's because of that reservation that's introduced in the last few paragraphs. It isn't entirely clear, but that's certainly my reading of it. And I think a lot of the commentators on this case have said effectively the 1986 document was the trust, and it's just that the 88 letter was providing the extrinsic evidence to properly identify the subject matter.
The point that the judge makes, the point that Sir Colin makes in 61, is that on the basis that the April 86 letter could be explained as referring to the land certificate, but even with that reservation, the subsequent letter in May 88 was clearly evidence for the purposes of 53(1)(b). But I don't think he says anywhere that the declaration was.
Well, I think the
Well,
declaration. I think if you look at paragraph 59.
yeah, and then
Yeah.
60,
Yeah.
such declaration.
Yes, I think my reading.
Oh
is
yeah, okay,
that-
got you. Yes,
that
I follow.
it's the 86 settlement document. It's
The
a formal
settlement
document
Yes,
that was
Yes,
the declaration
yes.
of trust.
But it didn't do the job on the evidence because it didn't refer to the house.
Well, arguably, I'm not even sure Colin Ryan was persuaded by his own reservation, because he does say if that reservation is justified. So it's a sort of for avoidance of doubt point about the evidence, because the judge below had decided the 86 document was sufficient. So one is really looking for the intention in our case when the mortgage document was signed. And previous intentions to do things on separate occasions when the fund had no separate personality are not relevant for that purpose. They are relevant background, of course, which I will come to. The judgment obviously refers to Paul and Constance. Constance in paragraph 58. And I should deal with that case because it's much relied on by the appellants. It's at AB 494. 2020. Now, this is the case. Well, first of all, just in terms of what the court says one should look at, which is the subject we were on, if you look at page 4 of our report, one sees Lord Justice Scarman saying in the last 3 lines, just above F, it is of course right that one should consider the various things that were said and done by the plaintiff and the deceased during their time together against their own background and in their own circumstances. So one looks at the whole chronology of what was said or done, and it also refers to that all the circumstances is repeated on page 6 of the report, just below letter E on page 6. The question therefore is whether in all the circumstances the use of these words on numerous occasions, etc. Now, obviously each case depends on its own facts. I tried to say it. But this was, I submit, a very generous and a borderline case. And the same seems to be acknowledged with what Lord Justice Scarman says about it. He says in this page 6 of the report that these were unsophisticated people, unsophisticated person declaring the trust if there was a trust in a domestic setting. They were putting money from a personal injury claim and from their joint bingo winnings into a bank account. It was, as Lord Justice Scarman says beside letter C on the page we're on, the decision was influenced by features of the history of the relationship. The case obviously concerns personal property. The context was very, very different to this case. And it's noticeable that even then, at letter D, Lord Justice Scarman, well, we can see, it refers to the fact that people may think this is a borderline case because it's not easy to pinpoint a specific moment of declaration. So there is discomfort, I suggest, that he could not pinpoint a specific moment of declaration in this case. And it's very context specific. and you will see at the foot of the page, Lord Justice Bridge emphasises below letter H, four lines from the end, the context in which the words were spoken. Now, this case, and indeed Roe in France, one about the boat, these are, in my submission, outlier cases that are a very long way from the case that we are.
Well,
dealing with here.
Lord Justice Garland obviously thought it could and probably should have been pleaded and argued as either implied or constructive trust.
Yes.
But he makes the point that it was never put that way, so they've
Yeah.
got to deal with it on the
On
basis
express
of
trust.
express trust.
Yes, and it's well, there's a lot been written in this area, but the comments. Well, you have my submission in my podcast on this. It was a domestic situation, and it was quite a generous decision in its circumstances. But it's problematic not to be able, to say the least, not to be able to decide when a trust is created. It is problematic, we have also cited in re Cousins, which is at Parties Bundle 3 at tab 69, page 9. 1448. And we've cited it for what Mr. Justice Neville says on 2 occasions. It's quite well known, cited in many of the textbooks, about the need for a present irrevocable declaration to be made. And he says it in the report at page 9, in the middle of the page. And it's repeated, I'll take it from page 10 at the end of the report, where he says, in the present case, I find no writing sufficient. This is the second main paragraph on page 10. To satisfy the statute of frauds, nor am I satisfied by the evidence that there was ever any present and irrevocable intention on the part of Cousins to declare himself a trustee. And we also cited re Sheavesman, which is quite often cited for the proposition that the court ought not to be astute to discover indications of such intention, trust intention. That's at the in the Authorities Bundle 3, tab 71, page at page 22. 1481. And it's the passage in the middle of the top paragraph there. It is true that by the use possibly of unguarded language, a person may create a trust, as Monsieur Jourdain taught prose without knowing it, but unless an intention to create a trust is clearly to be collected from the language used and the circumstances of the case, I think the court ought not to be astute to discover indications of such an intention, etc. I mean, the appellants say, well, the facts of these cases are different. Well, of course they are. They're different cases. But I mean, Sheavesman was a contractual arrangement, and Cousins was about bookkeeping entries. But they make the point that you are looking for a present intention to create a trust, and you should take care to ensure that that present intention has been shown. Now, there's an important other dimension here in self-declaration cases, my lords and my lady, which I ought to emphasize. It's brought out very nicely in the Agnew and Douglas article, which we cite, which I will go to. I'll just give you the reference at the moment so we can get it up. It's the 5th Authorities Bundle at 150. And it's this, that in a self-declaration case, unlike a transfer and trust case, the legal title remains with the settlor. So the declaration is the only relevant act or transaction. It is the transaction, it's the only relevant legal event. The existence constitutes the trust. And what that means is that the settlor must intend by the declaration, by that specific statement, for the trust to come into being. And of course, as we know, the trust has to be constituted at a specific point in time. Now, the Agnew and Douglas article, I'm obviously not going to go through it all, but if we could pick it up at page 3, please, of the report. 3017. And we'll pick it up in the first full paragraph. When one turns to self-declarations, because the legal title remains with the settlor, there's no legally relevant act or transaction other than the declaration itself. This alone is effective to change the settlor's status from absolute owner to trustee and give the beneficiary equitable title. It follows the declaration does more than simply provide evidence of the settlor's intention. It quotes me saying effectively, it is in itself the transaction. And then says the difference between transfers and trusts and self-declaration lies in the role played by the declaration. In the latter case, because the declaration is the only legally relevant event, the courts will require specific evidence of a specific act of declaration in order to find a trust. Then goes on to comment on the problems of Paul and Constance. Just following that, there's possibly 2 other consequential passages. Moving forward to 8, page 8 in our report, and just above the heading, what is a declaration? Pulling these threads together, we can see the importance attached to the declaration of trust. It's not merely a necessary fact for the establishment of the trust, it's the legally relevant transaction, the existence of which constitutes the trust. And I think there's a further reference, I'll just see if we need it. Yes, at the foot of page 18, in the conclusions, right at the last line, secondly, the settlor must intend by their very words or acts to constitute the trust relationship. It's obviously a powerful thing to declare oneself a trustee of a beneficial interest in property, potentially very valuable property, just by the use of certain words. And if declarations can be oral, then there doesn't even need to be any writing. So the court requires a specific act of declaration, not simply to evidence the settlor's intention, but as the transaction itself. And why is that important here? That's to show and to emphasize that it has to be intended by the mortgage documents to create a trust. Those are leaving aside the amended defense for a moment, those are the only candidates. So they must objectively intend by those specific statements to create the trust. The Agnew article also brings out by reference to cases that it isn't enough to show an intention to hold property rights for the benefit of another. You have to intend the consequences to follow from the declaration. They cite a number of cases. I'll take you to just one, which is the Fairpack decision at Authorities Bundle 4 at 102. 2136. And this you might remember from the news at the time was the Christmas savings scheme when the company went into administration, and there had been attempts by the directors in the days before the administration to ring-fence certain money to return it to customers. And Mr. Justice Mann, if we can pick it up from page 15, paragraph 47, page 15, paragraph 47, my lord.
That must be page 16 then.
Well, both. I was going to start at I was going to start at 45 actually.
Okay.
But he says 2150. Starting at the 4th line, the right-hand side, the directors clearly manifested an intention to create a trust, but they have to do something in the nature of a declaration in order actually to create it. So he found on the facts, and it's by reference to conversations with their solicitors previously referred to in the judgment, that the directors had manifested an intention to create a trust, and it wasn't a future intention. This company was about to go into administration. It was a very present intention to create a trust. They had to, as far as they saw it. But they still had to do something to create the trust, and they had to execute the deed, and they had to do something in the nature of a declaration to create the trust. The deed in this case had errors in it, which is why there was an attempt to rely on the director's intention alone. But if the intention to hold for another was enough, then the director's intention would have been sufficient, but it wasn't. And in the event, the judge rectified the declaration document in that case. But the appellants quibble with our insistence on saying present intention, but they do say, the fund do say in the supplemental skeleton at paragraph 19, I won't go there in the interest of time, it's an uncontroversial requirement that the three certainties necessary to declare a trust are all satisfied at a single point in time, at which the declaration of trust establishes the trust relationship. And our point in time has, of course, to be when the mortgage documents were signed. So moving to the facts as found by the judge, these, we're not challenging them, they're not controversial for these purposes, although they may have been fought over to some extent at trial. So I can probably take them from the judgment itself. The judge found, as your lordships know, that as a fact that NIOC had a mistaken belief expressed on multiple occasions, so outwardly manifested on multiple occasions, that the fund already owned NIOC House. And it was expressed in many documents cited by the judge. And it was NIOC's primary case at trial that NIOC House was owned by the fund under the Iranian law of Appellant. And that should be recognised pursuant to the Recognition of Trusts Act 1987. And there was an alternative English law case. But the concept of Amanat was explained by the judge, excuse me, at CB 15, page 173, at paragraphs 35 to 36. The court is, I'm sure, familiar. I mean, for present purposes, I would invite you to note there's no division of legal and beneficial ownership in an Amanat. There's one concept of absolute ownership. The owner entrusts the asset to the Amen but retains ownership. So the Amen acquires no ownership interest, and an Amanat cannot be equated to an Amen cannot be equated with a trustee. And you'll see in paragraph 36 that it was agreed by the experts that an Amanat was established under NIOC's articles, and that's also apparent from later in the judgment. And the facts, your lordships have read the judgments, so I won't need to go through it in any detail. It's this really, the facts from this point of view really start at paragraph 56, where on page 176, CB 15 176, where the judge refers to the original board meeting of NIOC in December 1979, where the conclusion was reached that NIOC was the property of the retirement fund. Remembering, of course, it has no legal personality at this time or for many years to come, although the Iranian parties didn't know that. And at paragraph 60 over the page, page 177, the judge decides that that was the result of a mistaken view of how Iranian law operated in relation to the way the purchase had been financed. And we then get a whole series of documents through the years which record the retirement fund's ownership of the property. I don't think it's necessary to go through these. They were, they're all referred to the documents. These documents are in the judgment at paragraph 70. There are other ones at paragraph 77. well, sorry, paragraph 77 is a summary, beg your pardon, of the position reached by the year 2000 that NIOC was the absolute owner of NIOC House, but a record saying it was the property of the fund reflected a mistaken expression of opinion by the board formed in 1979. And the judge then, as you can see from the heading at the foot of page 180, considers the period 2001 to 2011, and you then get further documents cited at paragraphs 80, 84, 85 and 88 in this regard, and that leads to a summary at paragraph 89, the foot of page 182, where the summary of the period 2001 to 2011 that NIOC and the retirement fund continue to consider that NIOC accounts belong to the retirement fund. And the judge then considers the period 2012 through to 2020 on page 183. And again, further documents, you will see on page 184 at paragraph 97, he cites a document where the Iranian parties are eliding custodian, trustee and amin in the document cited at 97. And then as the last couple of lines of the extract, and then further documents at paragraph 100 and 102 to 104 dealing with the Cathcart exchanges. One option, it's said there, 103, one option would be to enter a trust deed, but that of course is never done. And then to conclude the story, he concludes the Mr. Cathcart's involvement story in paragraphs 108 to 111 of the judgment. And notwithstanding all of that, there was no transfer, as the judge says, in 111, and no evidence as to why. But in paragraph 118, your lordships will see over on page 187, summarising the period up to 2020, which includes our period of the mortgage, that NIOC continues to believe that the retirement fund was the owner, and there was reluctant to transfer a title, but a willingness to state in the register that it held as trustee, and there's further references later in the judgment to the mistaken belief. Now, there was a mistake. It turned out this belief was mistaken on the judge's findings, but if NIOC has a mistaken belief that the fund already owns the property and has done for many years, first of all, it's got no reason to be involved in declaring an English law trust over that property in favour of the fund. I mean, and it's one thing to assert or reassert a mistaken belief that ownership already vests in the fund. It's another thing to demonstrate an intention to create an English law trust. All the more so when you consider how NIOC understood that the retirement fund already owned NIOC House, that is through an eminent structure, which does not recognise split title. Which is why we say it's factually inconsistent for NIOC to believe that the fund already owns the property absolutely under an eminent, but also intends to split title. And when you come to the mortgage documents viewed with that context, and the mortgage itself is at SB 1 tab 40, it's at page 274. As I'm sure the court knows, the part relied on, which is under representations, is at page 287. The bottom of foot of 286 onto the top of 287 is the passage relied on. The mortgagor's warrant that's in the date of this deed, and then at the top of the next page, pension fund, Staving and Staff Welfare of Oil Industry is the sole beneficial owner. NIOC is the legal owner of the mortgage property. That's the key and really only phrase relied on. When you come to consider that in its proper context, in our submission, it's apparent that the judge conflated two things. That is a present intention to create a trust on the one hand, and recording a mistaken belief about ownership already vesting in the retirement fund, a mistaken prior belief they already had and had for a long, long time. And so if you look at the document and give it a properly contextual construction, it's a recital of a mistaken belief in an existing state of affairs. Now, it's confusing amanats and English law trusts and thinking this is how the fund's existing ownership is classified or described under English law. It's effectively an English analogue or shorthand for the fund's existing Iranian law ownership. It certainly isn't an intention to effect any change in the fund's ownership of NIOC House or to create new interests under English law. And as we know from the authorities, declaration of trust has to be clear and unequivocal. When you actually see the context, the reference to legal and beneficial ownership has originally come from Mr. Cathcart and his understanding of the existing position based on what he knew and had been told when he became involved, which he translated as amounting to a custodian trusteeship. I mean, his was an erroneous interpretation.
The judge found that Mr. Cathcart had dropped out of the picture. At an earlier date in 2019.
Well, it's January 2019.
Yeah, whereas this document is dated September 2019.
That is correct. But
so whoever was responsible for the legal beneficial analysis, it doesn't look as if it was Mr. Cathcart.
It's true that Mr. Cathcart, the last involvement we see is January 2019. But this idea that a custodian trusteeship under English law was effectively an English analogue from what you've already got is something that originates with him. And it's a confusion that permeates all the way through.
Was there any evidence at trial as to who prepared the mortgage? I mean, it's actually on Stevenson Harwood's paper.
It is on Stevenson Harwood's.
And they were the solicitors for Bank Melly.
The draft was exchanged between the English solicitors. There is actually some of the emails in there which I can pick up. There is it's between Stevenson Harwood and
Bank Melly and
for Bank Melly and
Eversheds.
And Eversheds. So it goes between English solicitors, but you will see, interestingly, so far as that is concerned, that is actually it's revealing in this sense because between the mortgage document and the land certificate, which comes in January, you can see that the confusion continued because when an application is made to register the mortgage, and you can pick this up in Supplementary Bundle 2, tab 41 at 321. An application is made to register the mortgage. You see in this document, the third piece of text, unfortunately we're unable to complete, this is the land registry, your application until you're able to deal with the following. And so they're asking this of Eversheds for the mortgagor, mortgagors, and the over the page at 322, the foot of the page, item 7, they refer to this representation we've just been looking at. item 7, and then at the end of the page, there's no restriction in the proprietorship register of title, which would indicate the land is held on trust. In the absence of a copy of the trust deed made between NIOC and the fund, the link between the parties is unclear. And the email correspondence between Eversheds and NTT on these requisitions, asking NTT to, which is a subsidiary of the fund, to advise if there was a trust deed, and if so, please provide it. That's behind item SB 242. And you have, I won't go through all of the email correspondence, but effectively, a couple of documents are forwarded by NTT, which are not the trust deed. They're not being a trust deed, of course. You see that at the top of page 326. You see Evershed saying, well, this isn't that document's not a trust deed. Incidentally, the documents that were forwarded weren't disclosed. And at 325, there's another document that's hopefully forwarded by NTT, but you see that no trust deed could be produced, no declaration of trust could be produced, because you see Evershed's response to the land registry at behind tab 43 at page 333, where in the third paragraph they say our client advises the property was originally purchased by NIOC over 40 years ago, and at some point since, as the full amount of the purchase price has been paid by the pensions fund, then the beneficial ownership transferred to the fund for the benefit of the employees. However, NIOC never formally changed ownership. Now, that account is wrong, and it's also something of a mangling of English and Iranian law. And of course, the other obvious point is when asked by the land registry to produce a deed of trust, they couldn't, and they didn't rely on their mortgage documents, of course. Now, the appellants. So just to summarize, we say the mortgage documents are a mistaken statement of an historical state of affairs. I should have shown your lordships and my lady the land certificate as well, just so you have it in mind. It's at tab 44, SB 244. This is in standard form at the passage relied on in this regard is at, typically I've lost it for a second. 339, I'm told.
Which is 348 electronic.
Yes, it's here. Status of schedules, disclosures, the legal interest in the property is held by the company, the beneficial interest is held by the beneficial owner. So it's the same, basically the same statement. And we've seen that there's the same confusion, as we would say, persisting. Now, in creating a trust, it's not necessary, as has been said, to use technical words, but words like trust and so on. You don't have to use technical words, but the words must be clear and unequivocal and irrevocable, obviously. And the words of the mortgage documents are not. They're a confused expression of a description of a pre-existing state of affairs. And we would make similar criticisms, not that it matters particularly, of the obiter findings the judge made about some previous documentation, which we made in paragraphs 182 and 183 of his judgment, because Mr. Cathcart in those documents, assuming for a moment he was authorised, was reciting his own mistaken belief in an existing state of affairs based on what he knew and which he translated as amounting in English law to a custodian trusteeship. And it was common ground that a custodian trusteeship couldn't apply here because it's a creature of statute and NIOC was not a person who could be a custodian trustee. And I think the examination of Mr. Cathcart brought out that he had not in fact satisfied himself on English law principles that a custodian trusteeship applied. So I think this would be, sorry, give me one moment, Arnold. I mean, Mr. Dewan is also drawing my attention to the fact that in the lead up to the mortgage, there is email exchanges with Eversheds, between Eversheds and Stevenson Harwood at SB 35232, where they say in the main body of text that they've not been provided with any evidence of the fact that the legal title is said to be owned by the National Iranian Oil Company, the beneficial ownership by the pensioner. Now, so pulling those strands together,
So the information that goes into the mortgage deed, and it's actually in an earlier document, so I was looking at that. There's a facility agreement at tab 37 dated the 17th of June, which also prepared by Stevenson Harwood, which also has title to property on page 241.
Yes.
In similar terms. So that information has obviously come from Eversheds.
yes,
And what the email at 232 is saying, well, in effect, is saying, well, this is what you told us, so we haven't actually seen any evidence of it.
we haven't seen any evidence of it. Yes, so it's a perpetuation of this confusion. And you know, nobody is here trying to create a new trust. It's a perpetuation of a confused state of affairs, partly confused because of Mr. Cathcart's involvement. And contextually it's very important. Since we're looking at what did they intend to do by executing the mortgage documents, what did they intend to do? Did they intend to create a new trust under English law? Answer no. They didn't. And this is all objective. I'm not transgressing on subjective intent here. This is the settlor's intention as objectively ascertained from the outward manifestations in the documents. And so, if as it happens, the witnesses of for NIOC and the fund gave evidence that of this belief, this long-standing belief. Some of it's referred to in the judgment, but the witness statements, they give a whole list of documents said to evidence this belief in beneficial ownership going back years and years and years and years. It was all of a piece. It was all consistent. Mr. Bayat and Mr. Zainodin, Mr. Bayat, who appeared for NTT, and Mr. Zainodin, who appeared for NIOC. Putting the strands together, there was no reason first for NIOC to intend to declare a trust through the mortgage documents. And the judge never addressed the objective question of why would NIOC intend to declare a trust at this time. He didn't actually address that question. And acquiring legal personality is not an answer because NIOC was unaware of that. And it's not something that could have been known until 2024. We also rely on other objective indicia like the fact it's a financing transaction. That's not an obvious vehicle to be declaring trusts. We've referred our skeleton to the negotiations being on the basis that there is an existing ownership in the fund. And it's true that the judge, and one of the criticisms made in the appellant skeletons is that the judge refers to many of these matters elsewhere in his judgment. That's true, but it's kind of our point. The point is that when, and we don't challenge that, when he came to interpreting the mortgage documents, he did not take account of the obvious relevance and consequences of these findings. And just to look at that, if one looks at the judgment where he does address these issues at page CB 15, page 199, and this is when the judge is dealing with the mortgage, the 2019 mortgage, in paragraphs 185 through to 191. He deals with the land certificate at 191 in a single paragraph. Deals with the mortgage between 185 and 190. He focuses pretty much exclusively on the words used in the mortgage deed and the mortgage documents. The other context is briefly referred to in 189, some bits of other context. But he dismisses those almost always by saying, but the wording is clear. But he hasn't taken account of the context which I have explained to the court today. And when he comes to deal, he does in part refer to that exchange with the land registry in that paragraph towards the end of 189. He refers in part because he doesn't. But this is a question of law, and one is looking afresh at the interpretation in the full context. Yes, he has dealt with that incident in 117 and 118 paragraphs of his judgment. So he does deal with that, the exchanges with the registry. But the exercise we are engaged in here is to determine whether it's been properly interpreted in all the circumstances. And in relation to the land certificate at the top of page 200, the judge deals with it very shortly, and he only mentions the words used. Doesn't mention any context at all in relation to the land certificates in paragraph 191. So that brings me to the authorities said by the appellants to show that you can still objectively intend a trust should exist, even if it's coupled with a mistaken belief that the trust existed at an earlier date. Well, first of all, there was no belief that a trust existed at an earlier date. There may have been a belief that an amanat arrangement existed at an earlier date. It wasn't a previous trust. I think the judge pulled the appellants up on that at the argument in the consequentials hearing, when it was attempted to suggest there was a long-standing belief in a trust. The first of the cases is re Northcliffe at Authorities Bundle 3, tab 87. 1851, and one sees from the head note there was a settlement in November 1911 by Lord Northcliffe in relation to after acquired property. The Lord then acquires 4 such properties, and by his will in March 1919 he appoints 2 trustees of the previous settlement as executors, and he declares that he confirms the settlement of November 1911 and declares the provisions in his will were in addition to those made in that settlement. And from the head note you can see that it appears that the will confirmed that 2 of the properties were referenced in the will, and the other 2 were added by codicils. So by his will he confirmed the previous settlement and declared that the will provisions were in addition to that. And the judge unsurprisingly read that as a declaration by the testator that he held the properties on the trusts of the settlement. Now, what does that tell us about our facts? Well, the settlor in Northcliffe had at least 2 reasons to be making a confirmatory declaration. First, the properties had been acquired, And second, he was making a will. It's not clear whether he thought the first settlement was effective or ineffective. But whether he did or not, he had reasons to be making confirmatory declarations. All these cases turn on their own facts. As to what intention is shown, there's no particularly novel legal principle involved here.
So there's nothing difficult about making a confirmatory declaration.
Well, you'd have to see, if you had to analyse which declaration was the effective one, you might have to look at the circumstances in detail to check.
Well, we know in this case none of the previous ones can have been because there was no personality, as it happens.
Correct, yes, in our case, yes. But you might get a case where a settler makes a declaration, then makes a second declaration, maybe it's in slightly different terms, and you might have to determine which one was the effective one. But in principle, a settler shouldn't really be making several declarations of the same thing, unless there's a good reason to do so.
Well, my question was just, is there a legal impediment to making a confirmatory declaration, which is how you describe the one in this case? And I think the answer is no, there's not, but you should find some good reason for doing it.
Yes, I mean, if yes. I think in this case, the case we're looking at, Northcliffe, we don't know if Lord Northcliffe thought his previous declaration was effective or ineffective. It said it was ineffective in law because of the after acquired element. But we don't know whether he thought it was effective or not. The law report doesn't tell us that. But what we do know is that he had good reasons to be clarifying the position in his will, because it was a will, and because he'd now acquired four properties. The other case relied on is Gray and the IRC, which we looked at before for different reasons, but it's in Bundle 2, Authorities Bundle 2 at 54. 938. And this is the Court of Appeal decision. And one could probably take it from page 2 of the decision, the head note, where we see that the settlor H made 5 settlements in 1949 and 1950. And then on the 18th of February 1955, he made an oral declaration of trust over shares, directed they be held on the trusts of the 5 settlements. That's also apparent from later in the judgment. But then on the 25th of March 1955, the trustees of the settlements executed 6 written declarations of trust, also signed by the settlor, reciting that they were the holders of the shares, and recited the settlor's oral direction and accepting the trust reposed in them, acknowledging and declaring they held the shares on trusts of the relevant settlements. And it was held in the case 2-1 by the Court of Appeal that the oral disposition was void under section 53(1)(c). That was upheld by the House of Lords, leaving aside that the case concerned shares and that the court treated this as a case under C and not B. Insofar as the court was saying that these were valid declarations of trust, there are obvious reasons why the parties would enter into the written declarations in March 1955, even though the settlor had made a previous oral declaration. The first, the principal reason is that the March 1955 declarations were entered into by the trustees of the written settlements previously entered into in 1945 and 1950 to give effect to the settlor's orally expressed intention and to accept their duties as trustee in relation to the shares and to record the terms on which they held the shares. That's all perfectly obvious and sensible. It's not a case of a settlor on a self-declaration trust having a mistaken understanding and then trying to correct it or whatever. The relevant property was shares. An oral declaration of trust could be effective. There's no indication in the case whether the settlor thought his oral declaration was effective or not, or had any mistaken view about anything. But the main point I ask you to take from this, that there were quite obvious reasons why, having made a previous oral declaration, trustees should then be putting it all down in writing. I'm going to move, if I may. Oh, sorry, there are some analogous cases relied on by the claimants. I don't have time to go through them. We've dealt with them in our skeleton. These are the cases about effectively imputing an intention to exercise a power. Those are not of analogous interest or informative for our case. There's nothing to suggest that this type of analogy can be used when the issue is whether an express trust was created at all. It might be relevant to whether a trustee of an existing trust has exercised a particular power, but they have no relevance at all to a question of whether a trust was created in the first place. Nor is there any basis to extend that type of rule to try and circumvent the formal requirements of the statute, as we have in our case. I'm moving, if I may, to the no authority issue, if with the court's permission. I should perhaps start in this issue saying that I make absolutely no criticism of Mr. Smuha or anyone else involved for the respondents at trial. And I preface anything I say on this with the no authority point by saying that, of course, I was not there. Trials are a dynamic process. The relative importance of different issues can evolve and ebb and flow during the whole process. From the materials I have seen, it does appear to be the case that the case of express trust based on the mortgage documents on the 25th of September 2019 did not loom large at trial. I noticed from the transcripts at day 5 of closings, Mr. Smuha in submissions described it as coming as news, and for which one had to, and I quote, dig into the bowels of the appellant's amended pleadings to find. But the focus at trial does appear to have been more on the earlier documents, and no doubt because the appellants were making a case that they had legal personality in 2001. But it does seem to, the mortgage documents as declarations of trust does seem to have had something of a muted profile, but I wasn't there, and legally the point is good or bad, and in this you'll have seen from the skeleton supporting the respondent's notice that it bears the signatures of most of the trial team, including 2 silks, Mr. Smuha being unavailable. Now, the no authority point, it's actually quite a short point, mercifully. The point is this, that it was for the appellants to show that the mortgage documents were valid declarations of trust if they wished to rely on them to defeat the Section 423 claims. And a necessary element of that case is that they show that insofar, a necessary element of that case, insofar as they wished to rely on them as declarations of trust, was that they had to show that they were signed with NIOC's authority. Now, I'll come, let me deal with the point first, and then I'll come to the question of if it's a new point, is it a new point and whether it should be allowed if it is a new point. But to deal with what the point is first, so we have it in context. These documents were executed in the case of the 2019 mortgage by Mr. Ragazar of NTT. And just to look at that again, it's referred to in the judgment. I think perhaps we might go straight to the, let's go straight to the documents. The mortgage documents SB 40 274, and here we're at 319. So SB 40 at 319. Now, and I'll show you the certificate in a moment. That's signed by Eversheds. But dealing with the mortgage first. Now, NIOC says in its main skeleton it was signed by Mr. Ragazar, who was appointed for that purpose by NTT. And the relevant power of attorney is disclosed, and it's at SB 34230. Now, this power of attorney, which of course says for NIOC has, it's executed, it purports to be executed as a deed, we see over the page 231. That's because under the Powers of Attorney Act, it would have to be executed as a deed if you wants to be a valid power of attorney, as Bousted reminds us. Now, just before we debate the correct interpretation of the provisions of this power of attorney, a couple of points on how this exercise should be approached. Powers of attorney have to be strictly construed. If I could take your lordships and my lady to Bousted at Authorities Bundle 5, page 165. 3277, yes. It's at page 16 of this extract. 3293. Construction of powers of attorney. Powers of attorney are strictly construed and are interpreted as giving only such authority as they confer expressly or by necessary implication. The following are the most important rules of construction, and we see at 3. General words do not confer general powers, but are limited to the purposes for which the authority is given and are construed as enlarging special powers only when necessary for that purpose. The point about having to be executed by deed is about 5 or 6 lines into 3015. Now, the second point I want to make before we go through the document itself is a point that I've touched on before, but I think it's important in this context. We get it from the Commissioner of Pakistan case at Authorities Bundle 2, tab 57, page 96. 1117. And this is the case which we've been close to this passage before, where Mr. Justice Marcus Smith cites the Court of Appeal in Day on a question of the powers conferred under a power of attorney, and the learned judge at page 96, bundle page 96, quotes at length from Day in the Court of Appeal. And makes the point at 97, paragraph 26, that's the paragraph 26 from Day, On the issue of the scope of authority, the recorder appears to have thought it axiomatic that the general power of attorney, by virtue of its very generality, authorised the solicitor to execute on Mrs. Day's behalf a conveyance of the property in such terms as he saw fit to facilitate the gateway mortgage. That was the view of the recorder. It's plainly wrong. The solicitor's actual authority is prescribed by any instructions expressly given by the client, whether or not those instructions are then implemented by the solicitor acting pursuant to a general power of attorney. And then talks about ostensible authority, which of course we're not concerned with in this way. Yes, the day and day goes on over the page at letter C to say not only was that analysis wrong for the reasons I've given, but something didn't address the critical question of Mr. Day's actual intention, and that it would be remarkable, in the passage I read before, the 28, would be a remarkable conclusion that there was power given to effectively give the legal and beneficial ownership to her son in that case. It would be a remarkable conclusion. And I also remind the court of the cases I showed the court yesterday, Reckitt and the Bowles case, where showing how difficult it is to establish, even through a power of attorney, a power to give the principal's property away. And at a minimum, it would have to require very specific words. Now, with that in mind, one looks at Supplementary Bundle, tab 34, page 320. We have, it's not a general power of attorney. It doesn't purport to be, and it's not a general power of attorney under Section 10 of the Powers of Attorney Act, because that has to say it's a general power of attorney and has to be in a specified form, which this is not. It gives some specific powers in A, which have to be strictly construed, to sign agreements including mortgages, to which B and C are ancillary. There is no document in A which is apt to cover a declaration of trust. So a declaration of trust is not within A to A, and it's B and C are just ancillary to A. So strictly construing the document as we have to, and even without clause D, it doesn't cover it. We're not within A. And D makes it clear that any sale or transfer of ownership of NIOC House is not covered. It's almost for an avoidance of doubt provision, because a sale or transfer of ownership wouldn't be within A anyway, save possibly to the limited extent necessary to execute the security or mortgage concerned. But I'm reliably told by Professor Davis that a mortgage doesn't confer an ownership interest. It's registered as a charge on the register. But this, in any event, the transfer and sale position is made express in D. Now, the appellants make the case based on the cases of Rahoda and Transfer that I mentioned before, that in law, creating a trust is not a sale or transfer, but it's the creation of a new equitable interest. We don't argue with that, but as a matter of construction of the power of attorney, if you can't sell or transfer ownership of NIOC House, then you, as you expressly can't do, then you obviously can't give it away. It's really a more obvious case. It's an A fortiori case. We say it's not within A anyway, but
this is all about granting of security of one kind or another.
But they wish to rely on it as a authority to declare
No, I understand
the
the point.
trust. Yes.
But A makes it
Oh,
clear
yes,
it's really
yes.
all about the granting of security, and
Precisely.
B and C are ancillary to A,
Yes,
and D is simply confirming that one thing they can't do in granting
Yeah.
of security is to sell it.
exactly, exactly. And if you can't sell it, it's kind of really obvious. You can't give it away.
No.
And
Are you asking us to make these findings on as to the construction of this document? Is that what we're being asked to do here?
yes, and it's a question of law.
Does it not have to be seen in its context?
I'll come to that because there is an argument that this point should not be allowed because the evidence might have been different.
Well, but just before we get to that, does it not have to be construed in its context?
Yes, but
Including all the parties understood that the property was already owned by, or believed the property was already beneficially owned, to put it loosely, by the fund.
yes, and if that's right, that's even more reason for them not to be authorising Mr. NTT or Ragazar to declare a trust because they didn't think a trust was needed.
Well, that might be right. What about D then? One might say that's one construes D as transfer of ownership of an NIOC house away from the person that we believe currently owns it, namely the fund.
Well, even if one reads it like that, this is a negative saying this is a thing you can't do. So it's a negative, it's not. So even if you were to read it that way, it doesn't really get NIOC there.
Well, it deals with your negative point.
Yeah, yes, I suppose yes. Yes, it may be. It may be that if they think that it already owns it, what they have in mind objectively is don't transfer it away from the fund.
Yeah.
Now that could be right.
We can't resolve that, can we? Because we don't have the evidence.
No, but I would suggest that doesn't matter because whether it means don't transfer it away from NIOC or don't transfer it away from the fund, it still does not on any legitimate interpretation grant a power to declare a trust.
And that's your
over the
point of
property.
A.
Yes,
Yeah.
yes. It doesn't on any view grant that power. So, and also just finally, just on that Rahoda and transfer point, that's as a matter of law, of course, we're looking at it as a matter of contractual interpretation here. And the reasonable person in a commercial context is going to think, well, if you can't transfer it, I can't sell it, obviously I can't give it away. So as I did say, it was a short point. It is quite a short point because I don't actually have any more submissions on what it means. There is a sort of sequel, but I probably won't go there because it's arguably inadmissible on the question of construction. But the judge does deal with what happens in the August 2022 transfer when NIOC and NTT went and got different authorities in order to transfer the properties. That's dealt with in the judgment at 135 Roman 2 and also at paragraph 137. But I don't think I can rely on that for a construction purpose because it comes after. The short point is the power of attorney did not authorize NTT to make a declaration of trust on behalf of NIOC. And that's a point of construction, it's a point of law. As to Eversheds and its signing of the 2020 land certificate.
Sorry, just before you leave it, it's common ground is that this is to be construed as governed by English law.
No one has suggested otherwise, and I suggest it's intent. Entity is an English company. It's intentionally executed as a deed in order to comply with to be a deed within the Power of Attorney Act.
And it relates to property in this.
It relates to property in England. So there's an intentionality about executing it as a deed because that's what the Power of Attorney Act requires. And so I don't think it's arguable that it's an Iranian law document. The Eversheds and its signing of the land certificate, that's at Supplementary Bundle 2, tab 44. And the signatures are, Evershed's signature is at page 369. Now, so far as this is concerned, NIOC obviously adduced no evidence of Evershed's retainer. It would be, to say the least, surprising if in the context of the mortgage transaction on English property, Eversheds were given express authority to declare a trust. We've cited Flenley's Law of Solicitors Liabilities. Perhaps we probably should look at that. And AB 5, that's tab 153, pages 2 to 3. 3159. Yes, well, I mean, none of this is a surprise to anyone, but the at the foot of bundle page 2, we get solicitor's authority to bind the client, and express authority. It makes the obvious point that actual authority depends, going over the page, on the express terms of the retainer. Of course it does. And then implied or incidental authority. The solicitor, perhaps I'll read from the following, page 4, please. We're picking it up 7, 8 lines in. On the other hand, a solicitor has no incidental authority to bind the client in matters of substance which reasonably require the decision of the client, which are not properly incidental to the solicitor's existing instructions. Some examples of this from the cases are as follows. Solicitor has no implied authority to accept service of a bankruptcy notice, to enter into a contract. And it cites at footnote 9, client seems to be plain from the cases which were cited to us, including Lockett, that the solicitor would have no authority to make any such bargain. In that case, it was just Tomlin said solicitors are not, absent specific authority, agents of their clients to conclude a contract. I suggest a declaration of trust would be an A4 Shirai case. And Eversheds themselves subsequently signed a statement of truth, which confirmed in the defence that the NIOC's primary case was that the fund owned under an Amanat arrangement, which would be inconsistent with Eversheds having been authorised to create an English trust in January of 2020. So the short point is there was no evidence at all before the court to support a finding that Eversheds have authority to declare a trust. I was going to move to the question of whether we should be allowed to run this point. My lord, I am conscious of the time and I'll wrap up as quickly as I can after the break.
Okay. Well, 5 minutes then, so just before 25 past on. Thank you.
very sharp with it. Oh, it's there, so it's written like that. Sorry. Is that an O or a 6?
It's 180.
Right.
Which one is that?
It's new, sharp.
Yeah, that's 180.
Right.
Sorry?
My lord, turning to the new point argument, there's some debate in the skeletons, as you have seen, about whether the judge made any findings on authority below, and the reference to the judge saying acting by its attorney, NTT, and so on. And the appellants say, well, that's an implied finding of authority. My lord, if it matters, I had added to the bundle a Supreme Court decision last year, Sharp and Vitera. It's been added at Authorities Bundle 180. And just to give you the paragraph references from Lord Hamlin, it's at 72, paragraph 72, 74 and 75. Page 15 on Opus, it's really just trying to unravel the question of what implied findings there may or may not be in the judgment in relation to authority, because the court here was dealing with an issue of whether the Court of Appeal had impermissibly made findings of fact that had not been made by the tribunal. And it's informative in that it suggests that what you are looking for is whether the inferred finding is one which inevitably follows from the findings which have been made. That's in paragraph 74. And from the findings made by the judge in our case, a couple of things are pretty clear. One is that it is even if there is an implied finding of authority, if there is, we say it's wrong for the reasons I've indicated as a matter of law. But even if there is an implied finding of authority, there isn't any finding about authority under Iranian law, and there isn't any finding about what the power of attorney means, because that does not inevitably follow from the findings that have been made. In fact, the judge obviously didn't turn his attention to that, and it wasn't brought to his attention. So if it's is it a new point? Should it be allowed? I won't go through the archaeology of the pleadings. The court has been shown the pleadings. What we say on our side is that what was clear from the pleadings is at least this, that it was an issue, and we say the burden was on NIOC in this respect, whether the mortgage documents constituted declarations of trust, whether they satisfied the requirements of section 53(1)(b), whether an agent's signature was sufficient, and in these respects it was made clear in the respondent's pleadings that it was for NIOC to particularize its case in this regard, and the burden was on them. And now, and we've cited Phipson on evidence. I'll just give the reference in the interest of time. AB6, tab 168, page 3, the uncontroversial proposition that where an allegation forms an essential part of a party's case, then proof of that allegation rests on that party. Now, so we say the burden was not, as far as this is concerned, on the respondent. I appreciate, of course, that this question is not just about the pleadings, it's about what happened at trial as well. And so far as that is concerned, I obviously have to accept that there was no focused argument on the authority issue at trial, and I have to accept that. Now, so we say it's not a new point in the sense that it was an issue and the burden was on the appellants, but I appreciate that the point was not followed through at trial. Now, if it is a new point for appeal purposes, then I'd submit that your lordship should allow it in this court. I think there's a strong feeling amongst those in the council team I have who are at trial that this is NIOC reversing a burden of proof, an adequately pleaded case. But in the event there wasn't a focused argument on it, a number of recent authorities have been cited on new points. Of course, one has to be cautious about new points, quite accept that. I would ask your lordships particularly to have regard to Hudson and Hathaway, which is an authorities bundle 3 at tab 64. And I know that her ladyship has referred to this case quite recently in the Phones for You appeal. 1324 in the PDF. The Hudson Hathaway Court of Appeal in 2022, Lord Justice Lewison giving the leading judgment. If we could pick it up at page 16, 339, citing Lord Justice Snowden in the Notting Hill case. There's no general rule that a point before a new point will be allowed. The case has to be exceptional. There's a spectrum of cases, and whether it's just to permit a new point will depend on an analysis of all the relevant factors, including in particular the nature of the proceedings, the nature of the new point, and any relevant prejudice. No two cases are exactly the same, of course. At paragraph 36 of this judgment, the next paragraph, the court notes, well, perhaps I'll pass over that point in the interest of time, but perhaps looking at paragraph 40 at page 17, the case is instructive as to how the court dealt with assertions in the course of evidence, that the course of evidence would have been different if the point had been taken. And the court at 40 deals with the assertion by the objecting party that if in that case, the section 53(1) point had been taken below. His client might have applied to rectify the relevant emails. And the court noted that documents was an objective exercise and emphasised that you had to show that relevant evidence might have been adduced to affect the case, and described this argument as purely theoretical. So if you're going to object on the grounds that evidence would have been different, there has to be a real possibility that the course of evidence may have been different, and that may have affected the outcome, and that's repeated in other cases. And with that in mind, one looks to see how it is said that this point would have affected the evidence below. And the NIOC supplementary skeleton is dealt with in one paragraph without detail being given. It's dealt with in paragraph 17 of their supplementary skeleton. I won't go there. The reference is Core Bundle 25 at 339. I preface this by saying that even if the respondent didn't take the point at trial, the burden of proving authority was on NIOC throughout, so they should, I would suggest, have approached the preparation of their evidence. That's to say, disclosure of witness statements on the basis they had to prove that they had declarations of trust which complied with section 53(1)(b). But the four potential elements of new evidence are, very briefly, one, it said evidence on the scope of NTT's authority. Well, that's a question of interpreting a written instrument, and we have the instrument here, and no other context, relevant context, has been suggested that could have been put forward to change the meaning of that document, which we've been through. And as for oral evidence, it would have been irrelevant to the objective interpretation anyway of the power of attorney, and would have been actually inconsistent with the evidence the witnesses did give, which was that the fund was already the owner. That's the belief that the fund was already the owner. The second item of new evidence is said evidence on the scope of Evershed's authority. Well, we've seen the position of the solicitors implied authority. The idea that Eversheds would have a retainer in relation to a mortgage transaction in England, which expressly authorised that firm to enter into a declaration of trust, is, with respect, somewhat fanciful. And we know that Evershed, subsequent to the land certificate, signed a statement of truth in the amended defence, where the primary case was very different. Third, evidence of ratification is suggested. Now, it never been specified until Mr. Thankey orally did so what evidence of ratification have been relied on, and he said the August transfer, said for the first time orally, but that, of course, is a transfer that was set aside under section 423, the judge ruling that the position should be restored to where we would have been if the transaction had not been entered into. So it's not a transaction that can have any legitimate effect. It's also not clear that a ratification is even legally relevant, because if some person is able to declare a trust, does that even include ratification? It goes back to a point we discussed previously. Does it even include ratification? So we're getting pretty speculative and theoretical as to whether there could have been relevant evidence. And the last one is Iranian law of agency. And in relation to the 2019 mortgage, the authority was governed by the power of attorney executed as a deed to comply with the Powers of Attorney Act. And it was obviously intended as an English law instrument in relation to an English company entity in respect of English property under English law. So it's difficult to see what possible relevance Iranian law would have had. And as to the land certificate, any chance that Evershed's retainer in relation to an English real property transaction was governed by Iranian law must be vanishingly small. So that's the authority case, Arnolds. I should, just to conclude on the authority case, NIOC says in its supplementary skeleton, paragraph 19, that it would not be conducive to fairness. So they pray in a general fairness grounds to allow us to take this authority point now. And of course, the court does need to take into account all the circumstances, as the cases have said. And I would suggest that there would be an unfairness in not allowing us to take the point in circumstances where we have a recalcitrant debtor defaulting under a judgment exceeding 2.6 billion, which is said at the highest level that not a single penny will be paid to Crescent, which has been found to have acted with the avoidance purpose by the judge in this case, and even having regard to their prior belief in a beneficial interest, they had the avoidance purpose. And instead of coming to court to argue their case, they deliberately transferred the property away in order to defeat the creditor claim. And all along this process, they have been engaged in multiple challenges to the awards that have been made. And those have been rejected at every stage, liability and remedy. And it would be, I suggest, most unfortunate if NIOC were to succeed in this case, if in fact they didn't have any authority and given authority properly to declare a trust. So that's the no authority point. My lords, I said I'd deal with the amended defence at the end because that's another new point that the appellants of the NIOC has put forward. Because ground 2 relies on the amended defence as a manifestation of the trust for the purposes of the Act. The amended defence was not relied on at trial as a document declaring or evidencing the trust. Those documents were listed in paragraph 11 of NIOC's trial skeleton. The reference is Supplementary Bundle 2, tab 50, page 484 to 487, and they do not include the amended defence. There was a different pleaded case about the amended defence, which you saw the other day in paragraph 8610 of the defence, amended defence, where the amended defence was said to be evidence of a previous declaration at a time unknown, which is a different case. The case put in NIOC's main skeleton at paragraph 36 is that the amended defence declared the trust because Evershare's signature must be treated as NIOC's signature pursuant to UBAF, which I've dealt with, and secondly that Mr. Howarth of Evershare's signature on the statement of truth on the amended defence satisfied the requirement of Regulation 4. Now there were no oral, this wasn't pressed orally by Mr. Thankey, and it may be that the amended defence is no longer relied on, but in case it is, the amended defence arguments do not work. First of all, the amended defence itself doesn't purport to declare a trust.
No, it doesn't identify itself as one of the documents relied upon as being a declaration of trust.
Yes.
Paragraph 9.
It makes a different case.
A Roman 12, this defence.
Your Lordship has the point, I'll move on.
Is it actually being relied on as a declaration? I thought it was
Well,
being
it
relied
is
on
in the
as a-
skeleton arguments
Okay.
on the appeal.
I understood it being relied on as evidence, but
I know it has. That's why I'm, well, in either case I'd have to deal with it, but it has, they are sorry, it's relied on as a manifestation of the trust.
yes.
Yes. But it's only going to become relevant if the mortgage documents don't work, and this has to be a declaration. That's the only, it could otherwise be relevant as evidence of a previous declaration, but you've got to find your declaration somewhere, and if it's not in the mortgage documents, then where is it? The second reason it doesn't work is that at the time of the amended defence, of course, NIOC had divested itself of the ownership by the August transfer, so it wasn't in a position to declare a trust. It wasn't some person able to declare a trust because it had transferred all of its interest away, absolutely. And at that time, the court had not transferred the interest back, never has transferred it back. No authority, as I've indicated, and also there's a case law which rightly treats late self-serving declarations of trust with a huge degree of caution. The most recent of those being Mr. Justice Pickens' case, That's a close invoice at AB 133,
Yeah.
which we have seen. And finally, just before sitting down, I ought to preemptively deal with this because I won't get another chance. That in answer to my Lord Justice Zacaroli's questions about previous authorities, previous commentaries on the statute of frauds, both sides seems to have been busy on that. But we will have all of these added to the bundle, so I haven't got time to go through them all now. We found a 1911 edition of Lewin and a Snell from 1920. No one suggests you could have agents under Section 7. There's a certain amount of debate about whether a trustee could declare the trust, and my friends have, I think, produced Hayton and Underhill, which refer to the fact that there was no agency provision under Section 7. And my friends have also produced, and maybe about to address your lordships on some other texts that, frankly, I've never heard of. We have Spence and Hayes. These are two different texts that I think are being produced. The authoritative status of these texts is obscure. In our researches over the lunch adjournment, it looks as though they've only had one edition, and one of them, Hayes, is an elementary view of common law. It used to be something of a more generalized text. And what we did manage to find out about Mr. Spence is that in his biography, in the National Biography, it said that he acquired an extensive practice, most of which he lost on taking silk, which sorry, we got to end on a lighter
When was that?
note.
To writing articles then.
Yes.
Yeah, plenty of time for writing.
Yes. So why didn't he have a second edition? Maybe it wasn't selling. Anyway, I mean, I think the point of citing those is that they make a general reference to by his agent lawfully authorised, referring generically to the statute of frauds, not citing Section 9 particularly. And the point is that none of this supports our Section 7 applying to agents. But my lords, unless I can assist you further, I should sit down.
Thank you very much, Mr. Thank you. Right.
My lord, in terms of reply, I think the plan is I will start with ground 1. And I suspect Mr. Thankey will follow the remainder of that, ground 2, 3, and probably 2.2, and finally Mr. Mumford, 2.1, the respondent's notice. Collectively, I think we would like, and really until when the court is willing to sit until, so probably 45 minutes.
Well, we really can only sit till 4:30.
And we will then work within that.
Tear your cloth, really.
Certainly. I'll begin then. By way of overview, on ground 1, I'm going to deal with historical materials first, then brief summary of the common law position, then look at statutory writing, then the different classes of trusts, transfer and self-declaration and any others, then look briefly at authorities and commentary, and finally conclude with questions whether land is special, as my learned friend said, and the question of fraud. I aim to do all of that in about 15 minutes. As you've heard, the parties were busy yesterday. I think Professor Davies and 3 of the juniors were all in Lincoln's Inn looking at books. Some of these have been added to the bundle. Can I begin? I'm going to take you to 3 of them. Start first of all, authority bundle. I think it's 182, Spence.
Well, that's certainly been added, may have been added on electronically.
It's added electronically.
That's fine, if we got it on screen, it's
Yes,
fine.
certainly. So, Spence, I think 1836. Over the page, please, page 2. And it's the second complete paragraph, beginning halfway down, trust estates. Now, I'll be grateful if you can just read from there to the bottom of the page, and then I'll explain what I draw from it. So it's really just, it's about halfway down just before B, and signed by the party bound or by his agent lawfully authorised. This is talking about a Section 9 situation, assignment of an equitable interest. We say this is authority that, despite the lack of reference to agents in Section 9, agents nonetheless could dispose of those equitable interests. This refers to two other authorities, Cruz and Hayes. One can see that from footnote B. I'm going to turn to them in turn. So the next one is AB 183. This is Cruz, Digest the Laws of England. Turn over to page 2, please. Bottom of the page, very short point. We can read it together. The first sentence, point 6. Any disposition of a trust by the beneficiary was formally binding on the trustees in a court of equity, but it was enacted by the Statute of Frauds, Section 9, and then quotes from the section. The point it's making that pre-1677, any disposition of a trust, no formality required, oral, otherwise unevidenced, could be made. It's a salient reminder of the common law position pre the Statute of Frauds. And finally, AB 181, Hayes Elementary View. Turn over the page, page 2, please. We're looking, one page further on to page 3, please. Yes, and if you can enlarge, we're looking at the right-hand page, internal page 71. Grateful. It's paragraph 88, the last few lines at the bottom. Again, this is talking about benefit of a trust transferred by any form of instrument, or rather by any instrument, however destitute of form, which expresses the intention, provided it be in writing and signed by the party to be bound or by his agent lawfully authorised. So again, some authority for the ability of agents to dispose of equitable interests under what was then Section 9. That's all we wanted to do by way of taking you to the other authorities. We've looked at elsewhere. It doesn't advance the position. We were simply answering the question from the court yesterday. Does any of the earlier versions of Lewin and Snell, and they're all consistent with what you've already seen. So there's no real point in going to them. And doesn't cast any particular light on some of the other questions we've looked at. In terms of historical material generally, the paramount principle in statutory construction remains that the legal meaning of the enactment is the meaning that conveys the legislative intention, one of the first principles I explained yesterday. The historical position is clearly an aid to this. Insofar as we know that, or can know that position with clarity, that is helpful. To the extent that you can infer certain reasons as to why things were done, that also is helpful. But inevitably, certainly with statutes of this antiquity, some of the matters of the draftsman's intentions have been lost to the passage of time. That is why the text is the starting place, so we can draw some help from this. But nonetheless, the ultimate question for the court is construction of the words before them. As my learned friend acknowledged, the drafting is not perfect, either in the Statute of Frauds or the 1925 Act. And some of the textual points he makes need to be borne in mind against that. The court has to do the best it can to interpret it, and must do so in light, amongst other things, of the legislative purpose. The parties agreed on that to one level. That's the prevention of fraud by perjured evidence. You've had reference to that yesterday. I won't take you to it again. Turning now to the common law, there's been no challenge to the qui facit position or the pre-1677 position. Prior to that, there was no limit on how one could declare a trust, on how one creates or disposes of an interest in land. All those requirements in writing, subsequent requirements in writing, whether of substance or evidence, are new requirements. They are limitations on the previous common law powers. We say in terms of the ability of an agent to declare a trust, repeat the point I've made about a surprising lack of authority on it, but it's merely one incidence of the general law. And if an agent can make a gift of land or sell land, why could it not declare a trust of land? Now turning to the wording of Section 7, in particular Section 53(1)(b). Number of points, some of which agreed. First of all, it's an evidential provision. Certainly Section 53(1)(b) is. Even Section 7, point picked up in argument this morning, that had two conflicting aspects of the wording. One, manifest and prove, which is very much the language of proof, but then the conclusive words, null and be of none effect. And the thing which the courts had to do with is to reconcile those two competing provisions, and the conclusion was in favour of it being an evidential provision, so non-compliance did not render a declaration void. I say that a large plank of my learned friend's submissions seek to undermine the difference between substantive and evidential provisions. Answering one of the questions asked by my lady as to why it is different, a number of reasons. First of all, section 53(1)(b) says nothing about who can declare a trust or how you declare a trust. It is qualitatively different from A and C in that regard. This is critical, and one has to revert back to the common law. And there we rely on the qui facit provision. I say the common law, my learned friend may refer to the prevailing law, and he said that on at least 2 occasions today in terms of analysing how a company signs a document. I can quote from the transcript, where a company settler is providing proof for the purposes of the section, it will have to comply with the prevailing law as to what constitutes signature by the company. It's exactly the same point in declaring a trust. The prevailing law, i.e. the common law, as to how a trust is declared. All the statutory provision addresses is how you manifest and prove a declaration of trust. It's signed writing by whoever is able to. We'll come back to the precise meaning of those words. This is a more informal process than the underlining the substantive disposition. As I said before, very different to A and C. Those are substantive requirements. You can call them formalities if you want, and they are to one degree, but they are substantive requirements for the underlying transaction. In the words of my learned friend, the protection has been reduced in B to an evidentiary position. And he acknowledges that, but he says that the protection should not be eroded further. Now, he also suggested there was an overlap between A and B. In the greatest respect, there isn't. They have different purposes. They may coexist. An obvious example would be a transfer of ownership of land, say by a TR1, with a declaration of trust. But they're two separate things serving two different purposes. So there's not an overlap. There may be now an overlap between B and C. Whether something is a declaration of trust under under B, or an assignment of the equitable interest under C, and it may be that some cases, such as Tierney now, would be looked at through the prism of 1C rather than 1B. But if my learned friend is correct, and there is a congruence between A and B, that would rather support the ability of agents to declare trusts under B. Now, I say that my learned friend cannot explain the change in language from the party to some person, and the best he does in relation to that is to rely upon the apparent difference between self-declarations of trust and transfer on trust, and I'll come back to that shortly. He said on more than one occasion that the legislature is clear when agents are permissible. 2 points in that. First of all, I say that Spence and Hayes, which we've now produced, show that's not to be the case. There's no express reference to agents in old section 9. Nonetheless, you've seen the support for the fact that agents could make dispositions. The second point, I say it's not a question of when agents are possible. The question, or the point is that the Act makes clear when agents have to be authorised in writing. That's one of the things that sections A and C achieve. B, by contrast, does not. My learned friend has also made the point about section 53 flipping in and out of the common law. If his point is that section A expressly refers to agents, B doesn't and C does, then the answer to that question is in the history of the antecedent provisions, to which they are now replacements. And that's an end to that point. As to whether there is a division between transfer and trust cases and self-declaration cases, and what, if any, impact that has on the meaning of some person able to declare a trust. In a way, there are three categories. There's the perhaps classic transfer on trust case, A transfers to B to hold on trust for C. There's the self-declaration case, which this would be one. And there's the third category, which is the Tierney case and also the Rochefoucauld case, where the original owner transfers to B, who then holds on trust for the original owner. And to coin a phrase, I say it's asking an awful lot of the statutory words that some person covers both situations, but nonetheless excludes an agent from the scope. In terms of whether, and this is one of the questions my lady asked yesterday, the party in section 9 was limited to the settler, my learned friend said, without taking it to any authority, that self-declaration only became a phenomenon in the early 19th century. Now, there's no evidence of that. I say to go back further. If the real concern leading to the statutory frauds was perjured evidence, in my submission, that is more likely to arise in self-declaration cases
I
than
think there
transfer
is,
and trust
just
cases.
on that, I think there is something in the academic commentary about that.
Yeah.
Actually about self-declarations only appearing limited.
Well, the case that's sometimes relied for the ex parte pi, which isn't in the bundle we haven't seen, is a case from 1811. It's just a proper reading that suggests that it goes back further than that.
Okay.
Now, even looking at these different categories, the self-declaration, the transfer on trust, and the existing trust case, even if a trust, in the transfer and trust case, that the trustee is someone who can provide the relevant proof, and you've seen some of the authority to that effect, I won't take you back to it, that doesn't help construe who some person able to declare the trust is, because the trustee in that case is not able to declare the trust. The trust has been declared by the settler transferring the property to B, in my scenario. Professor Uden probably gives the best rationale of who should be the relevant person to give the proof. He says it makes sense if it's the person who, but for the trust, would be the beneficial owner. That would be the settler in the pure self-declaration case. That would be the beneficial owner in the Tierney and Wood case. And that would be the trustee in what you might call the classic transfer and trust case. However, the law doesn't say that, and the law appears to give an option in the transfer and trust cases, but that does not help answer the question whether some person includes an agent, because whoever the person is who can, some person means more than one person.
Can I just be clear on something?
Certainly.
Do you accept that under section 7 of the 1677 Act, the person would be limited to the
Well, it's the party.
Sorry, the party
Yes.
would be limited to the settled, wouldn't include agents.
Would be, yeah, would be the settlor. Yes, but even if you're assuming back then that it was transfer and trust cases, so later on.
No, that could be the settlor or the trustee, but it excluded agents, did it, under
Well,
section 7?
That's perhaps there's a reading of it, it's the party.
Yeah.
But I say whatever the position was in that, the wording of 1925, some person who is able to.
So your
Goes
case is
beyond.
there was a change in the law in 1925 to expand from the person to the party to some person.
Yes, or
Is that
certainly,
right?
or even if it was reflecting, understanding the reality is that the current wording, some person, clearly goes beyond just the settler. That is not a tenable submission. That's not one advanced by my learned friend, which is why he introduces the transfer and trust position. I'm sure my lady was about to ask a question.
No, I'm just trying to understand your answer.
Well,
Was it yes to my lord?
ultimately,
There was a
yes, there was,
change.
yes.
Yeah.
There's a significant change in the wording, and that reflects the ability of an agent to declare a trust. One very small point on Garden Row, it's been described as a sub-trust case. Strictly speaking, it wasn't, because Mr. Wood made a direction that the property held on trust for him be held on behalf of his family after him. Now, not a lot changes on that, but simply for accuracy of what it was not a sub-trust case. He was not,
Tierney and Wood rather than,
sorry,
you mean Tierney and Wood?
Tierney and Wood, sorry,
You
yes.
said Garden and Row, you meant Tierney and Wood.
If I did, I clearly did, I apologise, I meant Tierney and Wood.
Tierney and
Yes.
Wood,
So that's not a sub-trust case, properly spoken. Turning to the authorities very briefly, clear point is there's nothing binding. My learned friend has sensibly sought to deflect the criticism I made on the authorities such as it is. In terms of the commentary, he's critical of the article by Harpham in particular, but I say that that is the best analysis of the situation. It weighs up the pros and cons. it provides some analysis which simply one cannot find in the authorities or the commentary upon which he relies. There's nothing in his point that some of the commentary starts with the assumption that an agent can't declare a trust before going to question that. Well, what's wrong with that? Would it be a better article if it reversed it and said agents should be allowed to declare a trust or evidence of trust? Actually, as it happens, the assumption to date has been they can't. Would it be better if it removed that assumption? There's analysis which one simply doesn't find in the authorities, the commentary upon which he relies. Turning to whether land is special, my learned friend makes a big play of this, that declaring a trust over land is a very significant thing to do. Clearly, it depends on the land. Even property, the value in this case, needs to be put in contrast against the judgment debt, against the value of the companies, the pension fund. He's made the point that it's particularly susceptible to fraud, but I would suggest that if the court is to be impressed by reference to the front pages of newspapers, which you referred to yesterday, the reality is that property fraud is to do with transfers and dispositions of property and not declarations of trust. One of the commentary he referred to, McGarry and Wade, says, I'll quote, "The rule for contracts for the disposition of land where the signature of an agent suffices, even if the agent's authority was given only by word of mouth. That's not a declaration of trust case, that's something else." So I'm not sure how far that takes him in relation to that. If the legislative purpose of preventing fraud were absolute, one would expect that Section B was in the same language as A and C. It was substantive provision stipulating that it had to be in writing, but it's not. And that's the difficulty with the entirety of his submission. Paradoxically, the judge's construction below takes away the possibility of a solicitor or other undoubted agent providing the necessary proof. I gave the example based on the variation of the facts in Ong and Ping, where perhaps in order to achieve certainty, the settlor asks her solicitor to write on her behalf to the members of her family. Some of the criticisms about the consequences of allowing agents to declare trusts to provide the necessary evidence are really a function of the general law of agency. One can make those points generally about agency. Doesn't the fact that people can operate by agents increase the scope of fraud? Well, if there is anything that's true of all commercial transactions and contracts, and it's nothing specific to the declaration of trusts of land. And the final point I wish to conclude on was by his will. So he's recognised that that cannot be determinative because you can't exclude the ability of a company to declare a trust. If I can read from the transcript yesterday, this is what my learned friend said. He said, "The will of an agent would be irrelevant. Agent's authority terminates on death, and a will doesn't take effect until death, so it isn't possible for an agent to declare the trust in its will." So this overlooks a number of facts. First of all, that someone can make a will via an agent. Secondly, the agent will be alive when that will is made. It doesn't matter if the agent dies the next day. The will survives and takes effect on the principal's death. So it's nothing to the point, and it simply cannot explain the company's position, which he's acknowledged. For the time, I shall sit down and hand over. Thank you.
My lord, my lords, my lady, I hate to start with a disagreement with Mr. Grant, but we don't accept that there was the change in wording between Section 7 of the Statute of Frauds and the LPA in the way that Mr. Grant has just suggested, because if we have AB 1, page 12 on the screen, Section 7 of the 1677 statute, we say some writing signed by the party who is by law enabled to declare such trust is broad enough to encapsulate an agent. If anything, the language of the change in the language of the LPA in 1925 was to make that position clearer. But we
That's
don't.
what I thought your case was, to be
Yes.
honest. I was slightly surprised when Mr. Grant made that concession,
Yes.
because I thought the whole point was what was being said. And that's really what these old textbooks show as well, that whether it's Section 7 or Section 9, an agent was included, even though they weren't expressly mentioned.
Precisely. The material,
The textbooks only cover section 9.
Yes. Well, I'm not sure. I think one of them may have been referring to.
No,
But
section
anyway, you're
so
but the logic would be if it's true of 9, it should be true of 7 as well.
that's precisely the point. There's no mention of anyone other
Yeah.
than the party in section 9. So the fact it was understood before the LPA 1925 is rather consistent with what
Yeah.
I've been saying. And we say the material change in from section 7 of the 1677 Act and the LPA is the deletion of the final words, null and utterly
Yeah.
void and of none effect. So that's all
The
I've.
court seem to have been ignoring those words for quite some time.
Yes. And the courts have been interpreting those words as if they didn't exist for
Right.
some considerable time, as my lord indicates. So turning, if I could, to ground 2, we say that the UBAF case does provide a complete answer in relation to the position of a party in the position of my clients. Even before section 4436A of the Companies Acts, there was the alternative of execution of a deed at common law, which involved the affixing of a seal, the company's seal on the document. So, notwithstanding that possibility, in UBAF, Lord Justice Ackner made clear that even in a statute, Lord Tenterden's Act, which required personal signature, signature by an authorised agent was sufficient. And there are, on analysis, we would say very few documents which require formal execution against that background of that decision in particular, and a deed being a classic example. So we say that UBAF provides a complete answer, and the fact that section 36A and section 44 hadn't been enacted doesn't make any difference to the analysis, because at common law it was possible to execute a document under the company's seal.
I thought you said execute a deed under a company's seal. So the common law is about deeds,
Execute a document under the company's
not
seal,
just deeds.
including deeds. Then, my lord, I'll come back, if I may, to some of the questions of the findings made by the judge in the context of the respondent's notice points, if I may. My lord, my learned friend made various points about the scope for fraud being huge on our analysis of the cases. In our submission, the answer to that possibility is simply all the forensic tools which are available to the court to test whether the allegation of a prior oral trust are to be believed or not. In Gardner and Rowe, that was solved by the jury making an appropriate finding. So, in a sense, it doesn't really advance the debate to say that there's scope for fraud if our analysis of the statute is correct, because the courts have tools at their disposal to test whether the prior declaration of trust is accurate or not. And come back to on ground 3 specifically, we do make the point that there is no English case law where a creditor has been able to invoke non-compliance with section 53(1)(b). No case has been cited, and we say that reflects the position that it's primarily a provision directed at the ability of beneficiaries to enforce trust against the putative trustee. I'll come back, if I may, in a moment to a point that arises under Gardner and Rowe. But we do say that the trust exists, whether it's oral or written, but a merely oral trust or a non-compliant document does exist as a fact, and the point that my Lord Justice Zacaroli put to my learned friend as to the status of the trust before any written evidence is produced, and we do say that Gardner and Rowe provides a complete answer to that point, and really there is no adequate answer from my learned friend on the effect of Gardner and Rowe, because if one starts at tab 50, authorities tab 50, page 3, (903) in the PDF. And the short point is that an oral declaration of trust is not something written in water. It has a status. If we look at the bottom of the bottom of the page at the Vice-Chancellor's judgment, he talks about this deed, therefore, in respect to the moral obligation on the trustee to give effect to his trust, would not in such a case have been considered as a mere voluntary deed. And we say that does have an impact in relation to section 423 when one comes to look at that. And then you'll see over the page at page 4, Vice-Chancellor makes a point 4 lines down, which is then echoed in the Lord Chancellor's judgment, that a trust does not pass by assignment in the bankruptcy. And if we go to the Lord Chancellor's judgment, the point my Lord Chancellor reverted to, authorities tab 51, page 2, at page 262, just above 2/3 of the way down, see that the Lord Chancellor says it's true that the property of a trader cannot be assigned by him after his bankruptcy. The property is no longer his, it is vested in his assignee, but property held in trust is not the property of the bankrupt, it does not pass to his assignees.
Well, then he makes the point, doesn't he, that the only question is therefore whether the declaration was founded on a previous trust, and he means an oral trust,
Yes.
or was altogether fraudulent. And that was the question that has been decided
By the jury. And that goes to the point I was making earlier, that whilst one might be sceptical about a prior oral declaration of trust, the court, in this case the jury, but the court has all the tools at its disposal to test the accuracy or not of such an allegation.
Yeah.
And I emphasise that an oral declaration of trust is not something written in water, and a good analogy which I gave in opening is a limitation defence. And my Lord Justice Zacaroli made the point when Mr. McQuater was speaking, that, for example, the trustee might not take the point on the absence of written evidence, and he might honour his quotes moral obligation, in which case the trust is executed and perfected. But similarly with a limitation defence, there's nothing forcing you to take it. The obligation, the underlying obligation still exists. If you don't assert the limitation defence, it doesn't disappear. And if you perform an obligation notwithstanding a limitation defence, there's no way you can unravel it, for example, because you made a mistake about the availability of your limitation defence if you perform your contractual obligations. Just very briefly, on Rochefoucauld and Bousted, I made clear in answers to my lady's questions that there was a limit to how far I was pushing that case, and it does seem to have been restricted in its application, including relatively recently to cases where there's a trust, an oral trust declared upon conveyance of property. But just in defence of Professor Swadling's article, he does have in his favour the fact that the Court of Appeal in Rochefoucauld and Bousted does in terms describe it as an express trust. And that's at page, it's A107, A tab 107, page 17. I'm sorry I don't have the PDF number, but that is precisely the express way in which it is described. So whether Professor Swadling is an outlier or not, we do submit he is correct.
What do you say to the point that even though the beneficiary interest may subsist, before it's this writing, the beneficiary needs something from the trustee in order to enforce the trust?
Yes.
So the trustee has something of value in his hands, the ability to say no or the ability to say yes. And in saying yes or transferring the estate, he's giving away something of value. For purely looking at 43, what do you say to that?
So my answer to that is that it's not, he does receive consideration because he's released from his trust obligation. So it's not a case where there's no consideration for the for transferring or executing the trust. And what he's giving away, in effect, is no more than the ability to create evidence.
Well, if in truth, if there weren't any writing, it's no more than what is described in Gardner Row as a moral obligation.
Yes.
Then you say he's relieved from his trust obligation, but the beneficiary couldn't enforce anything against
The beneficiary couldn't at that point in time, but it's a risky transaction for the trustee to undertake in those circumstances. There's a risk of evidentiary material emerging, and then we've got the point that the Lord Chancellor makes that even at that stage, before there's written evidence, the trust doesn't pass in bankruptcy, the trustee in bankruptcy. The Lords and my lady, very little was said on respondents' notice point 1, the various cases that Mr. McQuater referred to, Gissing and so on, and Rossett, we deal with in our written submissions. There, as I say, including Hodgson and Marks, points made by the Court of Appeal were based on an assumption. They're not cases where Section 53(1)(b) was being directly considered, so they don't really advance the debate. I need to leave time for Mr. Mumford, but just finally on Respondent's Notice, second part of the Respondent's Notice on authority, Mr. McQuater said the point received a muted profile at trial, and we would say it received no profile at all. If it had received some profile, you'd expect it to be shown to the court in some detail from the transcript, and really it received no attention whatsoever.
Okay.
And I showed the court the RFI, where you can see the points that were actually asserted by CGC, and nowhere is the authority point taken. And as I said earlier, the power of attorney was not adverted to at trial at all, wasn't referred to.
No.
I'll come back, if I may, to the power of attorney in a moment, but just to remind the court, so far as authority is concerned, one thing is crystal clear. If one looks at supplemental bundle, second supplemental bundle at tab 49, And the points I make on authority and the lack of attention to it also apply equally to if compliance was required with Section 44 of the Companies Act. But this is Crescent's trial skeleton, which I took you to at the outset. If we go, please, to tab 49. Page 424. You'll see at paragraph 100, the defendants rely upon a mortgage agreement entered into between NIOC Retirement Fund and Bank Melli, dated the 25th of September 2019. No suggestion whatsoever that NIOC wasn't authorised to enter into that agreement. It's explicitly accepted and put in terms that it was an agreement which involved NIOC, carries with it an implication that NIOC was a party to the agreement. And equally, I showed you as well E, which is the only reference you see to the certificate of title signed by Eversheds. And the findings that the judge made in the mortgage documents necessarily involve the same authority issue that would be required for the purposes of the UBAF decision or Section 44 of the Companies Act, the same analysis. So we do say that is strictly a point of law. And we do say that the judge necessarily found that the documents were executed by someone with NIOC's authority. And finally, if I could just come back on the POA, if we get that up on screen, please. It is Supplemental Bundle tab 34, page 230. And I echo the point made by my Lord Justice Zacaroli that this does have to be construed in context. And I showed the court the email exchanges between Mr. Cathcart, NTT and NIOC before the POA was entered into. And one can see that the purpose, the effect of that correspondence was to do whatever Bank Melli required in order to satisfy Bank Melli's requirement for confirmation of the legal status of the building. And in those circumstances, where it had been understood for some time that the fund was the beneficial owner of the building, there's nothing out with the scope of subparagraph A, for example, which precludes confirmation being given of the division between legal and beneficial ownership. And Mr. McQuaid didn't go to that email exchange, but we do say it would have been very important to analyse that exchange as relevant background to the POA in order to construe it properly, and none of that was done at trial. So, my lords, my lady, those points I wanted to make. I better leave time for Mr. Mumford.
My lords, my lady, on the declaration point or the intention point as Mr. McQuaid characterised it, can I just start briefly with the standard of appellate review? My learned friend seeks to rely on the Thorner case to say that this is akin to construing a contract and so is a question of law. We say not so. We're not simply construing a trust document here. We're working out if a trust came into existence. And that is characterised in the Paul and Constance case as a question of fact, and we would say there's no reason to depart from that approach to it. On any view, it remains an evaluative multifactorial exercise, which we would submit this court should be very slow to interfere with the judge's exercise of. My lord, next question is on previous understandings. My learned friend sought to diminish their significance. We obviously say they're crucial, but he also sought to characterize them as being confused and really understandings of an Iranian law amanat. My lord, that's not what the judge found. What the judge found, and it's paragraph 25 of the judgment, is that the previous understanding was that the fund was the beneficial owner. And that's the language he used. Now, either the judge was there thinking in terms of English law trust concepts, or alternatively, he was deliberately expressing himself in terms that were neutral as between an English law trust and an Iranian law amanat. And it comes back to the point I made in opening on this, that whilst there may be differences between the two systems of law as to what the custodian, let's call it that neutrally, has in terms of property interest, both systems of law understand the inverted commas true owner to be the beneficiary. And that's what matters for present purposes. So no relevant confusion, we submit. My learned friend then went on to Paul and Constance and Rowan Prance and described them as outliers. We say nevertheless they're clear authority for the proposition that one can declare a trust by simply stating what one already believes to be the position. The other cases he mentioned in his skeleton, can I just refer, my lord, my lady, to para 13 of our supplemental skeleton where we deal with those cases of Cousins and Shibsman. In places, my learned friend slipped into talking of the requirement legally being that by this specific declaration one intends to change or create a new interest. For the reasons I developed in opening, that isn't the law, and you heard my submissions on why one can't exclude a case where one already thinks one's created a trust. Indeed, it would be perverse to say that one cannot have an ongoing intent to be bound by a suitably clear outward statement of what one regards as being already true. And my learned friend also says there has to be some reason to declare a trust. Now, we would say one needs to be very careful about that submission. We don't accept that that's right. Insofar as he's saying there has to be a reason to declare a trust, he's slipping into saying that one has to have some subjective understanding of the legal effect.
Made the point, because if you think about it, if you had a document that said very clearly it was a declaration of trust, the reason for entering into it is neither here nor there. That would be, as you say, resorting to subjective intention.
Exactly. Either it's subjective intention or it's introducing some objective requirement that one has to understand the legal effect of what one's doing.
You could postulate an extreme example where somebody said that something was something and that they hadn't meant to do that, and it was agreed between the parties they hadn't meant to do that, and you could rectify it. But unless you could rectify it, the subjective intention is neither here nor there.
Indeed. And we say what's crucial in this case is that we did clearly intend formally to state outwardly to the world that NIOC was subject to trust obligations. And indeed, so far as it's relevant, there was good reason to do so, because we were entering into a transaction in relation to the property with a bank that was concerned to know who had what interest in the property. So if a good reason is required, there was a good reason to state outwardly and in a binding way, and of course we're warranting the truth of this, that one regards oneself as subject to trust obligations, and it would be perverse if the law were to require more of us to be bound. And it certainly can't be right that because we subjectively didn't appreciate that we were not previously bound, that ceases to have the effect it would otherwise have. Then, if I can be indulged just for maybe a minute more on two observations on the cases. Fairpack. That turned on the fact that the intent in that case was for there to be a formal document. It's not saying that as a matter of law there has to be some further step beyond the intent to be bound. It's simply saying that on the facts of that case where they chose to execute a document, that was where the relevant intent needed to be located. As then to the cases of Northcliffe and Gray, we say, striking in both cases, that there's no exploration of the reasons why the documents were executed. And as to Northcliffe in particular, what my learned friend said, or the way that he characterised it, is that what was needed was to clarify who owned what at the stage when one's declaring one's will. But insofar as it's relevant, we say so too in our case. At the stage when you're mortgaging a property, you need to clarify exactly who has what interest in it. So there's no relevant distinction to those cases, and they found a valid declaration, so too we say in ours. Unless I can assist further, that was going to be my reply.
Thank you very much, Mr. Mumford.
Very grateful.
Right, well, thank you all very much indeed for your extremely helpful submissions. We appreciate that this is, as it were, the Silks have done the talking, that the work that's gone into it will be teamwork. So on all sides, congratulations on the teamwork. And also, apart from an occasional spat, which seemed to be more good-humoured than some spats in this court, appeal has been conducted in exactly the sort of manner that we would expect this sort of case to be conducted. So you can congratulate you for that as well. We will obviously reserve our judgment. No promises as to when you'll get it, although we will do our very best to let you have something as soon as we can. When you get it, please pay attention to the terms of the embargo at the front of it, and you provide us with any typographical suggestions for typographical and similar corrections, not to invite the court to re-decide the case in your favour. And if in due course you can agree a draft order, then we'd be grateful. If you can't, then shorten written submissions on whatever issues remain. But it only remains to say, given it's towards the end of July, I hope everybody's going to have a summer holiday of some description, and that the sun shines. Thank you all very much.
All rise in favour.